appeal on the matter of Bell and the Commissioners of His Majesty's Revenue and Customs.
Good morning. Now, in this matter, there are, of course, three parties present and represented. We have had the benefit of reading the FTT decision and the UT decision and the skeleton arguments from all the parties. And in the light of that, it seems to us that although this is, of course, Mr. Bell's appeal, we note that he is being supported in his appeal by HMRC. Moreover, it was originally HMRC's application before the FTT. And in those circumstances, unless it would inconvenience any of you, we would suggest that it would make sense for us to hear from HMRC first. Is that convenient?
Of course, my lord.
Very good.
My lord, in this matter, I appear on behalf of HMRC with my learned friends, Ms. Goldring and Ms. Rao. The appellant is represented by my learned friend, Mr. Aiken, and the first respondent, Mr. Mitchell, is represented by my learned friend, Mr. Hickey, and Ms. Sheldon. In summary, our position can be encapsulated in 5 sentences. The Commissioner's position boils down to the proposition that in order to ensure fairness to both appellants, the Commissioners have an obligation to disclose material which may assist Mr. Bell to show that it was Mr. Mitchell who was running Universal and not him. Secondly, that obligation requires disclosure of material that goes beyond the strict confines of the Commissioner's pleaded case against Mr. Mitchell. Thirdly, the First Tier Tribunal rules are wide enough to permit that to occur. Fourthly, both tribunals below have accepted that disclosure may be ordered of relevant material, even if it goes beyond the express terms of the Commissioner's pleaded case in the statement of case. And fifth, the problem of applying a criterion of relevance in this case at this stage is shown by the fact that whilst the First Tier Tribunal decided that some material was irrelevant, the upper tribunal decided that it may have some potential relevance. And that's the material in categories 2B and 4. Turning then to our substantive submissions.
Well, before you proceed,
my lord,
can I ask you this question? Why has this got anything to do with disclosure at all? This was not an application by Mr. Bell for disclosure. This was an application by HMRC for determination as to whether there was any lawful objection on the part of Mr. Mitchell to HMRC voluntarily producing documents which HMRC has and which HMRC considers to be potentially relevant to the issues and is therefore minded to produce. Viewing the application through the prism of disclosure is bound to mislead, because that's not what it's about. Disclosure is all about compulsion. There is no question of compulsion in this case. Therefore, the correct starting point, I would suggest, is to ask from where, if anywhere, does HMRC derive power to to produce voluntarily documents which it has obtained as a result of investigations into a taxpayer, and in particular, documents which would otherwise be subject to a duty of confidentiality to the taxpayer. And on that footing, our starting point is Section 18 of the 2005 Act, which would seem to give a clear power to HMRC to produce such documents, because these are proceedings between parties, subject to the question of whether there's anything contrary to be found in the guidance from the Supreme Court in the Ingenious case. If there is, as would appear to be the case, power under Section 18, one then moves on to Rule 27 of the rules. And if there's nothing in the rules which prevents it either, then it would seem, prima facie, that HMRC can do what it was proposing to do. And the question then would be, on what possible basis can Mr. Mitchell object? And one might have thought that that would require a judicial review application on the part of Mr. Mitchell if he's going to challenge what would appear to be a lawful exercise by HMRC of powers which it has. Perhaps one might say, well, is judicial review really the appropriate route for such a challenge? Is there not some way in which Mr. Mitchell could raise an objection within the context of the proceedings, but query what the procedural route would be? And in any event, the substance of the objection would have to be the same, namely that HMRC can't lawfully do it. Maybe there might be some form of argument about abuse of process, but anyway, whatever basis one might think of for an objection, it would require something pretty strong, either public law error or abuse of process or something along those lines. And no such suggestion has ever been mounted.
My Lord, we respectfully agree with everything that your Lordship has just said.
Right, well, shall we look at Section 18 then?
Certainly, my Lord.
Does that mean, can I just be clear then, does that mean that this whole sequence of litigation really went wrong at the first instance because it was never really for the FTT to decide whether HMRC could or couldn't disclose those Mitchell documents to Bell?
Lady, yes.
So jurisdictionally we've got a bit of a problem right from the get-go.
Yes.
Okay.
But what motivated the HMRC was the apparent dispute between Mr. Bell and Mr. Mitchell.
Exactly.
Therefore, effectively coming to the court saying, please, we know of this objection, we need some comfort as to how to proceed.
It's not really for HMRC to look for comfort.
No, but
from
that's
the
how
FTT,
it feels.
But that's how it's happened.
Yeah.
So, Section 18, tab 17. Revenue and Customs officials may not, subsection 1, may not disclose information which is held by Revenue and Customs in connection with a function of the Revenue and Customs. The material in this case plainly meets that. It's material gathered during an investigation into Mr. Mitchell's tax affairs. Subsection 2, subsection 1 does not apply to a disclosure. C, which is made for the purposes of civil proceedings relating to a matter in respect of which Revenue and Customs have functions. Plainly, these appeals by Mr. Bell and Mr. Mitchell are such proceedings, and the proposal was that, well, HMRC had drafted a list of documents which they were proposing to produce in the proceedings. Mr. Mitchell objected to the production of some of those documents, and hence the commissioners went to the First Tier Tribunal to look for comfort.
It struck me that 18.2a potentially applied because the proposed disclosure by HMRC to Bell could well be said to be for a function of HMRC. In other words, getting
Yes,
the
my
right
lady.
amount of tax out of whichever one of them may or
Yes.
may not turn out to be liable.
Yes, my lady.
And it didn't contravene any restriction imposed by the Commissioner. So A was in point, C was certainly in point.
Yes.
It looks like HMRC went for E because they wanted an order of the court, of the FTT, telling them what
Yes.
to do. But I think we've covered that ground.
Yes.
That wasn't really the right way of
No.
going about it.
No, one hesitates to say, but perhaps they should have had the courage of their convictions.
Well, that's an interesting point. I mean, one can understand why, as a council of prudence and caution, HMRC made the application that it did. But I think what you're accepting is that, with the wisdom of hindsight, the correct course would have been to say, well, we HMRC are proposing to exercise our powers under section 18(2), paragraph A and or C. It's up for you, Mr. Mitchell, to challenge that if you have grounds.
Yes.
Yeah.
Absolutely.
Could he have sought an injunction? I'm just trying to find
The most obvious route that
his application was it tab 2 of the supplementary bundle, isn't it? The jurisdiction he invoked was a direction under rules 256.15.2b,
yes.
and he'd referred to the respondent. Sorry, it's a supplementary bundle tab 2, page 10.
Yes.
He
Rules
referred, and this again is where perhaps confusion comes in. Let's wait for my lord to. He refers to the respondent's application for disclosure.
Yeah.
Should be refused.
Yeah.
Etc. Etc.
No,
But could he have sought an injunction?
it's the wrong end of the telescope.
Yeah.
To refer to the respondent's application for disclosure. He could have. The route that comes to mind is to apply for a direction under Rule 15.2 to exclude evidence.
And that is referred to, in fairness,
Yes.
as being the alternative 1B application.
Yeah.
But surely Rule 15 comes downstream.
Yep.
Because that's about admissibility in evidence. And the test is unfairness.
Absolutely.
And we're not there yet.
No.
Of course, even if it is correct that HMRC may lawfully produce the documents to Mr. Bell, and Mr. Mitchell has no lawful objection to that, it doesn't follow at all that the documents will ever be admitted in evidence, because Mr. Mitchell can apply later for a ruling that that would be unfair. But the criterion there would be unfairness. It would not be relevance.
No. I agree 100%, my lord. There appears to have been a confusion between disclosure and admissibility here. Disclosure comes first. The commissioners have the power to disclose in Section 18. They also have the power under Rule 27 to produce documents, even if they aren't going to rely upon them.
So the two, so I don't see Section 18 as being entirely discrete from Rule 27. They don't live together very happily, and I've slightly struggled to see how they can cohabit. But they do have, there is the power under both
Yes.
for HMRC to provide documents,
Yes.
to use a neutral term, to third
Yes.
parties, bounded by, in the case of Section 18, public law
Yes.
duties. And that, I think, would extend to well, it would be a rationality boundary, wouldn't it? So they couldn't go around disclosing irrelevant, completely irrelevant documents, because that would be just
Yes.
fanciful. It would be
Yes.
an improper use of power. But here, by wanting to give Bell documents that emanate from Mitchell that might be broadly said to touch on the issues as between Mitchell and Bell at the hearing, that's, one would say, is plainly within their
Yes.
public law, the scope of their public law powers.
Yes.
And you could read that into the Rule 27 produce bit
Yes.
as well.
Yes, my lady. Yes.
Shall we have a look at Rule 27 then?
Tab 23F, page 331.
I should know the answer to this. As the rule applies to standard and complex cases. This was a complex case?
Yes,
Yeah.
lady. Yes.
Thank you.
So this comes at quite an early stage in the proceedings, the requirement to produce a list. It comes after the commissioners have stated their case in their statement of case. But there's no obligation on the appellants to have produced a detailed pleading. They have to produce a notice of appeal, but there's no requirement as to the level of particularity or specificity within Rule 20. And so at the stage when the respondents are producing their list, they know their case, hopefully they do, but they don't necessarily know the appellant's case.
But as a matter of fact, when were the notices, did the notices of appeal predate the 42-day time limit?
The HMRC have put in its statement of case, haven't it?
We have, my lady.
Yes.
Sorry.
The notice of appeal is tab 7 and 8 of the supplementary bundle,
Yeah.
March 2018.
Yes. Sorry.
No. And then, sorry, statement of case, July.
Yes. We can see from Mr. Bell's notice of appeal, tab 7 of the supplementary bundle, page 51.
Yeah.
This is where he sets out his grounds for appeal. Essentially, he's saying,
Don't know.
it wasn't me,
Yeah.
I wasn't in control, and the evidence of the last paragraph on page 51, the evidence upon which HMRC relies is extracted by way of interviews. The appellant's not yet been provided with access to the interview notes, unable to comment on any statements by third parties. Reserves the right to amend these grounds once further evidence becomes available. So that was the flag that was put up, which the commissioners responded to.
And Mitchell was briefer at page 61. He simply said, I don't agree that I could not have been unaware of the inaccuracies, and I'm appealing the decision.
Yes, no.
Yeah.
So 2 points. We have very brief grounds of appeal from both. The cutthroat nature of the defence has not become fully apparent at that stage. But clearly the commissioners are on notice that Mr. Bell wishes to see the material they have in relation to Mr. Mitchell. And indeed, the commissioners go on to rely on that material in their pleaded case against Mr. Bell. We go to the statement of the case, tab 9, page 81. Paragraph 48, subparagraph 3. So this is the pleading that Mr. Bell is a shadow director, and the commissioners rely on what Mr. Mitchell has said in his disclosures to HMRC during their investigations into him, Mr. Mitchell. So there are two reasons why the Mitchell documents would appear on the Commissioner's list of documents. One, Mr. Bell has essentially asked for them. And two, the Commissioners have relied on parts of those documents. And one can understand that Mr. Bell would say, well, I'd like to look at all of those documents to see whether there are any inconsistencies, contradictions in Mr. Mitchell's account, which may support my defence that it wasn't me, it was him.
Does it depend on Mr. Bell asking for these documents, or even in the absence of that, would these documents fall into a general category of liable to assist a potential defence at that stage?
The latter, my lady. The disclosure to be made under Rule 27 does not depend on any request being made. In fact, it's not a specific disclosure provision.
Well, no, it's not. And hence my lady's question raises the question of whether there is a duty upon HMRC as well as a power. The questions I was asking you earlier were framed in terms of HMRC's power under Section 18 and Rule 27. And what I was suggesting to you, and you were agreeing, was that HMRC plainly had power voluntarily to produce these documents absent public law error or abuse of process possibly being put forward by Mr. Mitchell, and there having been no such application. But of course, it is germane, as my lady indicates, for us also to consider the other side of the coin, which is the extent to which there's a duty on HMRC.
There's no express duty in tribunal rules or in the CRCA. Different tribunals at different times have referred to duty of candour, although that's more commonly found, that expression is more commonly used in public law.
Well, indeed so.
I'm sure you will get to it, Mr. Pusey, and I don't want to take you out of course at all, but I was very interested in the judgment of Lady Justice Rose, as she was, where she seems to consider precisely this point about what is the scope. It goes back to the obligation of disclosure. What is the scope of disclosure in different sorts of cases, and that might be a bridge.
Absolutely. And Lady Justice Rose, she then made the point that there are different disclosure regimes according to the cases that come before the tribunal.
Different standards, as I understood. It's not that the regime is different, because we know what the regime is, Rule 27, but that the way you apply that is a flexible standard depending on what you've got in front of you.
Thank you. Yes, that's absolutely right.
But of course that kicks in when one gets disclosure. And at present, we don't even have an application for disclosure.
No. This case is concerned with whether the commissioners have the power to provide these documents to Mr. Bell. And we would say that they plainly do.
Now, I don't want to take you out of your course, but my lady has referred to the judgment of Lady Justice Rose, and I have glanced at that. And at the moment, I'm not clear that she says anything that's relevant to the question of power.
No.
But if you think there is something there, then by all means take us to it.
Now just go to that. It's tab 13, paragraph 42. Page 234. This doesn't really touch on power, but it's something that I think it's worth bearing in mind when we're looking at the provisions in the FTT. Reference there to the case of e-buyer and the proposition that the FTT rules have been enacted for important as well as simple cases, and that the rule provided a procedure for disclosure in the FTT, which was intended to be different from that which applied in civil litigation generally. So simply making the point that we're not really in CPR territory here. The FTT has its own specific powers and regime.
Can you assist me? One thing that I find very puzzling about all of this is that I'm struggling at the moment to see what Rule 27, subparagraph 2, has to do with disclosure at all. Because I would have thought that disclosure comes from Rule 5 and the Tribunal's case management powers. And in particular, paragraph 3D, which, as it seems to me, plainly empowers the Tribunal to order disclosure. And of course, this is important because, as I'm sure everybody appreciates, disclosure is all about compulsion. It's extracting a party's private documents under compulsion through the power of the state. And that's why one has to be a little cautious about disclosure. And there has to be a clear power to order it, and it has to be ordered only in appropriate circumstances. And hence all the human rights jurisprudence on that topic, because it's an invasion of privacy. But as it seems to me at the moment, Rule 27.2 has nothing to do with disclosure, because it's not about compulsion, it's about what parties are going to do voluntarily.
It's about...
Whereas Rule 5.3D is all about disclosure, and it's all about empowering the tribunal to compel documents to be disclosed and inspected.
I hesitate to put a different view, but this...
But it's your job to tell me I'm wrong if I am wrong.
Well, I'm going to very respectfully submit that Rule 27 is about the disclosure of one's case. One can't keep one's case hidden. One has to tell the other side what that case is. One does that partly in the statement of case. One does that partly by listing the documents and material that one's going to rely on.
And there is an element of compulsion in Rule 27. So it is an obligation.
Yes.
And it is the language is as close to one gets to what one could slip into, perhaps, but it resonates with concepts of disclosure.
Yes.
And Rule 5 is wide enough to cover the disclosure process, but this does seem to be targeted at something
Yes.
akin to, if not identical to, yes, perhaps that's not dangerous, but there is an element of compulsion, that's all I'm saying, I
Yes.
suppose, at this stage in Rule 27.
Rule 5 is specific disclosure,
Yeah.
if we were
Yeah.
to try and equate them to CPR. Rule 5 is you ask the tribunal for a direction that the other party disclose specific
Well,
certain.
I don't understand this. How does one get this out of the language of Rule 27(2)(b), which the party providing the list, let's take it in stages, intends to rely upon?
Yes.
So that's saying, I've got documents which support my case. And of course, if they support my case, I'm going to produce them voluntarily.
But one might not choose to do it then, my lord. One might just choose to hold them back until the morning of the appeal and then say, here's my bundle, this is what we're relying on. So 27(2) requires them to be disclosed at an early stage in the proceedings. They can be added to, of course, but they're required to be disclosed early to assist in both parties preparing their cases efficiently and to assist the tribunal in narrowing the issues.
And you come back to there's two limbs. I mean, so if we call it, I've called it basic disclosure in Rule 27 and then specific disclosure in Rule 5. The basic disclosure, which works in 98% of tribunal cases, absolutely fine, because you've just got HMRC and the taxpayer, and they both know what the other one's got. So it's not really a big deal. So the party provides the list of what they intend to rely on. So in other words, the documents which support their case, you'd assume. And then there's this rather sort of baggy second limb, or produce in the proceedings.
Yeah.
The taxpayers typically won't produce very much in the proceedings, and HMRC might produce a bit more.
Yes.
I mean,
Yes.
But what we don't see in 27(2)(b) is any reference to adverse documents. There's no obligation in 27(2)(b) to produce documents which are adverse to your case.
No, they're not. There isn't, my lord. That's absolutely right.
And can it be said that is why Section 18 is an important check, because HMRC can disclose, being the investigating body in the normal way, as it were, will have collected during its investigations documents for and against,
Yes.
that therefore the power under Section 18 is a very important balance to the one-sided aspect that my Lord has pointed out in Rule 27.
Yes. It's and as the Lord has already pointed out, it has a sort of public law frame of reference, Section 18.
But can one apply into Section 18 a duty to disclose as well as a power? A bit sceptical about that. Doesn't seem to be framed in terms of duties. It seems to be framed in terms of powers.
Yes. Just to go back to smart price for one moment, in paragraph 53, Lady Justice Rose expressed the view that HMRC should give access to any exonerating material. That's paragraph 53 on page 238, tab 13.
Sorry, where? Paragraph 53, letter?
Paragraph 53 at the bottom of the page, page 238, which is highlighted. I agree with the conclusion.
It's vital. Yeah.
Well, I think we can all agree with that statement, that it's vital that the taxpayer has access to exonerating material in the hands of HMRC. I mean, that's plainly correct. But the question is, how is that given effect to that desideratum? And what I think we've established so far is that HMRC plainly has power under Section 18 and Rule 27(2) to produce such documents. But from whence does the duty to do so derive?
Plainly there's a power within Rule 5 for the tribunal to order disclosure, and so
Quite so.
the party may apply
Quite so.
and say, we wish to see these categories of documents. We believe or understand that they will assist our case. But there isn't anything expressed within Rule 27 that imposes an obligation to disclose documents that are adverse to one's case, and whether that's the respondent or the appellant.
And nor is there in Section 18 anything express. And isn't that why you get into Lady Justice Rose? Because what she says is you've got to look at the sort of case you're dealing with to
Yes.
understand what is the obligation,
Yes.
not just the power, the obligation of disclosure in that case. So in her case, she was dealing with some sort of warehousing regulation, something or other, wasn't she?
Yes, and it was a discretionary decision where the commissioners could take away somebody's authorisation, and it was important to know what they'd taken into account in coming to that decision.
Quite so. So, paragraph 53, she says, in terms, the disclosure limited to what is required by Rule 27.2 would not be sufficient even as a starting point. In other words, you can't just look at the rule and say, well, I've disclosed what I'm intending to rely on, and the other bit's a bit baggy, so I'm not going to worry about that. You have to, if you're HMRC, you have to think about the sort of case that you're dealing with.
Yes.
And it comes back to, I think, to what you were suggesting earlier, namely the suggestion that although it's nowhere in the Act or the rules, there is a duty of candour.
Yeah.
From whence this comes is not immediately apparent, but that seems to be the implication.
Yes.
That's the closest.
Functions,
Yeah.
Yes.
care and management.
Certainly, yes, care and management, public law obligations.
Duty of fair dealing.
Yes.
Not, I mean,
Yes.
it would be that sort of thing.
Yes. It would be,
Public authority obligations.
yeah, it'd be an abuse of power to deliberately sit on documents that could assist the party that one's dealing with, if one knows that they are adverse. I do put that caveat on it, that it has to be, and this comes back
that's
to...
the problem, isn't it? You see, and this is why I'm a bit sceptical about this, because in public law proceedings, the duty of candour extends to a duty to look for adverse material. Whereas, is that the case here? Plainly, if HMRC has documents which in its possession, which is adverse to HMRC's case and knows that to be the case, so then it's not difficult to see that there ought to be a duty upon HMRC to produce. But would you accept that it goes so far as a duty to search?
Not within the rules and statute that we've been looking at so far, or any other rules that I'm aware of. These are public law obligations.
And the difference is, as I think about it now, that the backdrop to all of this is that HMRC have got a whole panoply of other powers to come and investigate and uplift documents from your premises. So again, in the typical two-party HMRC and one other party in tribunal situation, HMRC, they've already got everything that they think it inculpates the appellant. It came from the appellant, so they know the appellant's got it. So this all becomes a little bit academic.
Yes.
What's odd about this case is the two appellants on a, as rivals.
Absolutely. It's what my Lord Justice Newey alluded to in granting permission. Potentially wider significance where one appellant seeks to block the other from seeing something.
Just, Ms. Peter, just wanted to finish off that point.
Sorry,
that
I'm
may
sorry.
be why you don't see any express requirement anywhere about the duty to check what's in your... Well, you do talk... Rule 27 does talk about what's in your possession, custody or control. It uses that old language.
Yes.
But there isn't any wider express duty because this is just a bit of a much wider picture of HMRC's powers.
Yes. And the rules apply both to HMRC and to appellants.
And just following what my Lord's thought process through and why duty of candour doesn't necessarily sit easily, we have to remember this is not a public law challenge. It's sort of adversarial here, isn't it? So it's a different context.
We've moved slightly away from where this case started and the statutory framework.
The proceedings are properly described as adversarial. These
Yes,
proceedings,
they are.
yes, they are.
Yes. But they're clearly in the tribunal. The tribunal's dealing with both represented and unrepresented appellants, The degree of detail one's going to see in a list of documents is going to vary widely. Rule 27 is drafted so as to apply to both appellants and respondents. And as was said in e-buyer, it applies both to simple cases and to complex cases. It has a lot of ground to cover.
So is there anything else in Smart Price that would assist us?
I don't think so, my lord, not from our perspective. Just check. Perhaps the reference in paragraph 45(1) on page 235. This is taken from the case of Namley.
Sorry, can you repeat?
Page 235, my lady, paragraph 45, Roman numeral 1, the highlighted section F. An assessment made by the litigant as to relevance is determinative unless and until another party puts evidence before the court demonstrating that the assessment is wrong or unreliable.
But that's about relevance.
Yes. Yes, that's moving on to perhaps a different subject.
That was a submission as well, wasn't it?
It was, yes. No, I don't think there's anything else.
Well, only to note that Lady Justice Rose does look at all the different models, including the JR model of duty of candour disclosure. She looks at the standard model, CPR 31.6.
Yes.
She looks at FCA disclosure in those sorts of financial conduct cases, and then comes to 53. It's to select the model that she thinks is the most appropriate in this sort of case, which she says is a standard disclosure, rule 31.6 of the CPR, even though that's nowhere mentioned in the VAT rules.
No. For that particular type of case, yes, because the commissioners hold material that the appellants may not be aware of.
But is that the model then that we should be thinking about in this sort of case?
No, my lady, because this isn't an exercise of discretion by the commissioners. It's not taking away somebody's authorisation and forming a judgment as to whether they're fit and proper, which was the test there. This is, we've investigated your affairs and you owe us X amount.
Can I press a little bit? Is that not the trap that one might say the FTT fell into, of looking just at HMRC's case and saying that that's really as far as disclosure goes? That actually when you step back and you look at what obligations HMRC might be under in a case like this, would you not say to yourself that it's not enough just to disclose basic rule, I can't remember the number of it, 27.2 documents, because that leaves this gap as between Bell and Mitchell. So it's a very different case, obviously, from Smart Price. We're not looking at a discretionary decision at all, but the dynamics of this case might lead you to the same endpoint of saying you do have to disclose material which is adverse to your own or another party's case. It goes that far.
In this type of case, in this situation, one can see why that would be the correct approach. It can't really be read into the rules, but where one has two appellants and there's effectively a cutthroat, the commissioners and one appellant have material and the remaining appellant doesn't, then there's an inequality there.
But all of that goes to whether there's a duty or an obligation on HMRC to disclose, and obviously that's of interest to this court. But your primary point is it doesn't matter because you have power
Yes.
And you're willing, able and proposing to do it.
In this case, that's absolutely right. Yes, my lord.
But again, following this through, perhaps at some stage we'll look at the obligations of Mr. Bell and Mr. Mitchell, if any. But is it right, put the HMRC's position to one side, Mr. Mitchell and Mr. Bell may have documents adverse to their cases, which let's say Mr. Bell has documents adverse to his case, which Mr. Mitchell does not have, but Mr. Bell can sit on them, is that right?
Mr. Mitchell can seek an order for specific disclosure.
Under Rule 5.
Under Rule 5.
But why does it have to be specific disclosure? Why can he not make an application for an order for standard disclosure? Surely the FTT has power to make such an order.
It does, actually, my lord. You're quite right.
And in a case like this, one might have thought it was jolly opposite.
So I understand it. A general order. You actually, on the facts of this case, you've got to be. You must disclose documents upon which you rely and which are adverse, upon which the other party might rely.
Yes.
That's what is, yes. So not by reference to any specific meetings or documents or letters. Yes.
You never got there in this case, though.
Not yet.
I'm just wondering how far we need to go. So far as powers to disclose in Section 18 are concerned, that's only on HMRC, and that's really where this case begins. And one might say that's really the focal point of it. But if you'll forgive the judicial ramblings, if you go further and you say, well, actually, whatever HMRC was proposing to do as a matter of its power, it was under that obligation. Reading in Lady Justice Rose, because the obligation that applies to this piece of legislation must be of something that's a bit like standard disclosure. That standard would have to apply to all parties, wouldn't it? So they'd all be under mutual obligations. You can't just put one party under obligation.
No. Rule 27 applies to all parties, so
it would be the way you read Rule 27, and it would be equivalent in its application to all.
yes. Sorry, excuse me. Thank you. No, there's nothing else. I'm happy to develop my submissions on the other matters.
I'm not sure there's much you need to add, really. I think we covered the ground so far as you're concerned.
Thank you, my lord. Thank you.
Unless you think there's something we've missed.
May I just check my notes, please?
Thank you very much. So, Mr. Aiken, for you to go next.
Yes, my lord.
Since this is your appeal.
Well, yes, but the course of the last hour or so has rather affected the submissions that I was going to make.
Indeed.
And I do not think that it would be of any assistance to the court for me to go through my skeleton argument, given that the whole premise upon which this appeal now turns seems to have shifted somewhat.
Well, that's fair comment, yes.
So, on that basis, well, I'm going to be very brief indeed.
Presumably you would support the position that has emerged in discussion with Counsel for the Revenue.
That was precisely the point I was going to make first of all, yes.
Yes.
So the points that I now wish to make really are few in number. one of the issues which may have been superseded, but I will mention it, was the question of fairness as being a means of Mr. Mitchell resisting the disclosure of HMRC's documents.
Well, at the moment it seems to me that fairness is a question which comes in at a later stage. It comes in if there's an objection as to admissibility. Under the rules, the tribunal has power to exclude evidence if it would be unfair for it to be admitted. But that comes after production voluntarily and disclosure by compulsion. And moreover, I would have thought, is a decision to be taken when the case is fully pleaded out on all sides. Because it's only at that stage that you can really make a proper judgment as to fairness. And I think what that leads me to is this question. Would you accept that any decision as to fairness will be one to be taken at a later stage?
My Lord, I think I'm compelled to accept that, given, of course, of the hearing so far. The only point I would make in relation to that, and doubtless Mr. Hickey will correct me if I'm wrong, I see no reference to fairness in his skeleton argument before the court. At that point, the question of fairness was raised in the First Tier Tribunal and the Upper Tribunal, but does not appear to form part of his case as now pleaded.
Yes, but if I may, if you'll forgive the observation, I think that might be explained by the fact that he was meeting a somewhat different case, which was being put forward in your skeleton argument, which was all about relevance, looking at it from a disclosure perspective. And of course, if the right perspective is not one of disclosure and therefore not one of relevance in that sense, but rather HMRC's exercise of its powers to do something that it's proposing to do voluntarily, then of course the whole complexion of the matter looks a bit different.
Yes, my Lord. I suppose the point is that if Rule 27.2 is applied and Mr. Bell sees the documents, because Rule 27.3 requires a party that lists documents under 27.2 to provide copies, then Mr. Bell can take a view as to the fairness or unfairness, because he will have seen the documents and will be able to meet a question of fairness squarely.
Well, since we've got on to this question, perhaps it would be convenient if we had a look at Rule 15, which is in the authorities bundle at 23C, page 325. So it's paragraph 2b little Roman 3. Tribunal may exclude evidence that would otherwise be admissible where it would be unfair to admit the evidence. So, as I understand it, it's common grounds that even assuming that the documents are produced voluntarily by HMRC, the FTT has power to exclude such documents from being admitted in evidence. If I'm wrong about that, do tell me. But the question then is, when should that decision be taken and upon what basis?
Yes, well, the Upper Tribunal did not rest upon the question of unfairness.
Well, indeed so. You're right about that. But that's why I'm trying to see if there's a dispute before this court that we need to be addressing. Because, as I was suggesting to you a moment ago, at the moment it seems to me that the issue of fairness is one for another day. And what I'm trying to do is to see if you're disputing that, and if you are disputing it, upon what basis.
Well, the only basis upon which I can dispute it, my Lord, is that the upper tribunal has already considered the question of fairness with a view of the documents, which of course Mr. Bell has not had, and has found no unfairness.
Is it their express finding of no unfairness?
I'd have to go to the report.
But I'm puzzled because the UT dismissed Mr. Bell's appeal. So he couldn't have been saying that it was not unfair in relation to documents, disclosure of which was not going to be given, or production of which, to use a better term.
But it did not do so on the question of fairness or unfairness. It did so for a number of reasons, which were related to partly to the machinery of the actual application, or the lack of application by Mr. Bell. It was not Mr. Bell's application in the first place, and that weighed with the tribunal as to the upper tribunal as to what he could or could not.
Yes, but this is the whole point. I mean, you're making the submission, which I have no problem with whatsoever, that both tribunals approach the matter upon a wrong footing. Absolutely. But the question is, well, what are the consequences? And consequence one may be that you succeed in your appeal to the extent that HMRC can go ahead and produce the documents that it's intending to produce. But what I'm concerned to do is to establish whether there's any other consequence.
Well, the other consequence which I would submit follows is that if the question of if Mr. Bell's appeal to the upper tribunal was dismissed, but not on the question of fairness, then I see your lordship's point.
So can I rephrase my question in this way? Assume, for the purposes of this question, that the appeal is allowed to the extent that we rule that HMRC has power to produce the documents voluntarily, and that Mr. Mitchell has no basis for objecting to it. Is it your intention that Mr. Mitchell would thereafter be shut out from arguing that the documents should not be admitted in evidence because it would be unfair to do so?
Lord, in all conscience, I cannot say that I can make that submission.
That's clear, thank you.
There's only really one point that I now wish to make, and that's relating to the duty to disclose, which was discussed earlier. And I think your lordship's already made the point, but I'll emphasise it. The question as to whether there's a duty to disclose is, in the circumstances of this case, not relevant, because HMRC is seeking to exercise its power and to disclose under 27.
Well, technically I'm completely at one with you on that, subject to hearing what Mr. Hickey has to say. But you will appreciate that the reason for the questions from the court is that we have to try and look at this a little more broadly. I mean, this is an unusual case in two respects. Firstly, because of the three-party dimension and the cutthroat nature of the cases being run by the two appellants, but also because the issue has come up in circumstances where the party making the application, HMRC, is offering to produce documents voluntarily. But we need to take into account the possibility of situations in which production may not be voluntarily. And you're absolutely right, of course, the scenarios are different and the applicable rules and principles are different. But nevertheless, it's helpful to try and think about both sides of the coin, if I can put it that way. And that being so, if you can assist us with regard to any relevant duties, we'd be interested to hear from you.
Well, I can't add to what Mr. Pusey has already said.
Right.
In my submission, he's covered the ground, I would say satisfactorily.
Mr. Oaken, you said in the circumstances of the case, the duty of disclosure is not relevant because the HMRC is seeking to exercise its power to disclose under Rule 27. Do you mean power to disclose under Section 18?
Well, it's a two-stage process, my lady. Yes, Section 18 is the start of that, but Section 27 is the machinery.
That's the duty.
Rule 27.
There's a duty under Rule 27 and a power under Section 18.
That's correct, my lady.
So, if you're looking at what you say is the second stage, it's complying with its duty to disclose under Rule 27. Is that right?
Yes, my lady.
Right.
But I think you'd accept probably would be that the ambit of Rule 27 is itself unclear in many circumstances. It's very clear, the first bit's clear enough about the documents that a party is seeking to rely on, but the second bit about what it wants to produce is unclear.
Oh.
So it's just a bit difficult to call that a duty, at least a duty, without first of all thinking about what is the ambit of required disclosure in this case.
Yes, my lady. What I would say to that is that once HMRC have decided to exercise to follow their duty under Section 18, that takes us into Rule 27.
They have a power under Section 18. I don't think they have any obligations under Section 18.
I do beg your ladyship pardon. But once they have decided that they will disclose, then that brings us into Rule 27 2B.
But the reason for asking you these questions is that it's in your client's interest, potentially, to say that there's not merely a power but a duty, and therefore to identify the source of the duty. I mean, as it happens, the dispute before the court is about documents that HMRC are intending to produce voluntarily. But imagine this hypothesis, and this is purely hypothetical. I'm not suggesting that there's any reason for thinking this is actually the case. But suppose it be the case that there's a document lurking within HMRC's files which they've overlooked, and they're not currently intending to produce voluntarily, but which would assist Mr. Bell. Then the question of duty might become sharply relevant as far as your client is concerned. And the question, therefore, is, do you have any submissions to make as to the extent of HMRC's duty, as distinct from its power, and what the source of that duty might be?
My Lord, I do not have any arguments, any submissions to make on that point. It's sufficient for Mr. Bell's purpose and for HMRC to be prepared to exercise its power and to disclose.
Yeah. All right.
Well, unless there's anything else I can assist you with, I think those are actually my submissions.
Very good. Concise. Thank you very much. So, Mr. Hickey, over to you.
My Lord, thank you. If I may, I'll start with Section 18 of the 2005 Act. And as to Section 18, our position is as follows. nothing in section 18 that overrides the fundamental requirements of the common law regarding evidence, and that only admissible evidence should be relied upon. We respectfully submit there is a balance to be struck between the interests of a taxpayer in keeping private information confidential, which is irrelevant to the proceedings, and obviously striking a balance with the interests of the state in using information. But the filter in relation to what information can and should be deployed is determined by the law of evidence on admissibility, because only relevant evidence can and should be deployed for the purposes of litigation, and that acts as a filter to ensure information which is irrelevant to civil proceedings remains confidential. This is not a situation where Mr. Mitchell is seeking to suppress relevant confidential information. What is the basis for that submission? If I could invite the court to go to Legal Authorities Bundle, tab 9, page 22.
So Mr. Mitchell is not seeking to suppress relevant confidential information.
Yes. And of course, my lady, within the FTT decision and within the upper tribunal decision upholding Judge Mosedale's decision. Sorry.
I beg your pardon. So I'm sorry. I should have allowed you to finish what you were saying. Please finish, and then I'll ask my question.
My lord, thank you. In Judge Mosedale's decision, she reached a decision on 4 levels of relevance in relation to the disputed documents. If that decision were to be upheld, then HMRC and Mr. Mitchell's legal team will have to go through those 2 bundles, applying that filter, and obviously whatever Judge Mosedale has decided in accordance with that 4-level test is relevant will be provided to Mr. Bell.
So at the moment it's only 2B and 4 I think we're arguing about
Yes.
in reality, isn't it?
Yes, my lady.
And do you have a finding by Judge Mosedale that 2B and 4, 2B to an extent and 4 in totality, were not relevant because she looked at HMRC's pleaded case and
Yes.
took it from there?
Shall I go to that answer directly, or would you like me to deal with
Sorry,
section
yes.
18?
Before we get on to Judge Mosedale, can we finish on section 18? And you were going to take us to an authority, and plainly we need to look at that in due course. But just on section 18, I need to be clear as to what your submission is as to section 18. Do you dispute that section 18, subsection 2C and possibly 2A, empower HMRC voluntarily to produce documents within FTT proceedings?
My lord, going to the language of the section, which I think you have open in front of you, page
Yes.
303, I accept that section 18 in relation to confidentialities, 18.1 clearly sets the overriding principle that HMRC may not disclose information which is held by them in connection with the function of HMRC, but that's obviously subject to subsection 2. And in relation to point A, which my Lady Justice Whipple indicated, was potentially in point in these proceedings, which HMRC is entitled to, has the power to make disclosure for the purposes of function of revenue and customs. I don't think we have the section in the bundle, but of course the function of HMRC is the collection and management of taxes. And Roman 2 does not contravene any restriction imposed by the commissioners, and we're not aware of any. So I accept A does create a power. Equally, I accept on the face of the language of section 18 that 18.2c provides that HMRC can, for the purposes of civil proceedings, which includes tribunal proceedings, relating to a matter in respect to which the revenue and customs have functions. Clearly the function is the collection and management of taxes. So I accept on the face of it, section 18 gives the power to make disclosure of documents, voluntary
Right. So
disclosure.
you accept that there's power under section 18 on the part of HMRC to produce the documents voluntarily. We were debating with Mr. Pusey what mechanism of challenge there might be on the part of Mr. Mitchell to a decision by HMRC to exercise that power.
Yeah.
And one mechanism would be judicial review on public law grounds, but plainly you have not applied for judicial review, and I don't know if you would suggest that there is any public law error here. But is it your submission that there's any other mechanism available to Mr. Mitchell?
Yes, my lord, there is. I can answer that question directly or finish off on section 18 and in terms of our...
Well, if there's more on section 18, do tell us.
So there is more on section 18, but to be read with the Supreme Court decision in Ingenious, if I may.
All right.
And then I'll come to your lordship's question as to the appropriate mechanism for challenging any HMRC decision to make voluntary disclosure and what that mechanism
All right.
is. So if I could invite the court to go to tab 9, page 138, the Supreme Court decision in Ingenious. Has the court had the opportunity to read the sidelining?
Yes, I have.
Yes, I have.
Oh, thank you. In which case, if I could invite the court to go to paragraph 22, page 145. And this is a point which is emphasised in, obviously, section 18, subsection 1, which is the overriding obligation is confidentiality of taxpayer information. And Lord Toulson, at paragraph 22, comments, to take the present case, the general principle of HMRC's duty of confidentiality regarding the individual's taxpayers' affairs is long established. In 2011, Mr. Hartnett articulated it when refusing to give any information to the House of Commons Public Accounts Committee about taxpayers with whom HMRC had reached settlements. In passing the 2005 Act, Parliament cannot be supposed to have envisaged that by section 18.2a1, it was authorising HMRC officials to discuss its views of individual taxpayers in off-the-record discussions, whenever officials thought that this would be expedient for some collateral purpose connected with its functions, such as developing HMRC's relations with the press. If Parliament really intended to delegate to officials such a wide discretion, limited only by a rationality test in place of the ordinary principles of confidentiality applicable to public bodies, in respect of confidential or private information obtained under statutory powers or for a statutory purpose, it would have significantly emasculated the primary duty of confidentiality recognised in section 18.1. And then, if I could just take this court to page 144.
Well, just before you go on,
Sorry.
can you explain to us what you get out of that that's of assistance to you? Because, of course, that was a case all about disclosure to a journalist,
Yes.
which, prima facie, one would have thought HMRC had no relevant function at all.
Yes.
So it's not at all surprising that Lord Toulson approached the matter in the way that he did. But of course, here we're concerned with adversarial proceedings before a tribunal, and confidentiality is no bar to disclosure
Yes, my lord.
in adversarial proceedings. On the contrary, confidential documents are disclosed day in, day out in adversarial proceedings.
Yes, my lord. But stepping back, if I may, into the context of tax tribunal proceedings, and in terms of the relationship between taxpayer and HMRC, and of course, this court will be well aware that when HMRC opens any investigation into a taxpayer, and as it so happens, and I can take you to the revenue statement of case, both appellants were the subject of investigation for some 6-year period. So HMRC's had a considerable amount of time within which to investigate the appellants and formulate and prepare their statement of case. But during the course of that investigation, quite clearly, all information shared between either appellant is confidential. HMRC then decided in this matter to issue corporate liability notices against each of the Universal companies, Universal Projects and Universal Payroll. Those companies went into liquidation, and HMRC then decided to issue personal liability notices against each of the appellants, as they're entitled to do under paragraph 19 of Finance Act 2007, Schedule 24. Each appellant then put in a notice of appeal, which is in the supplementary bundle. At the point the notice of appeal went in, that engaged the First Tier Tribunal rules in terms of how each party is required to put their case. But everything I've described up until now, the information remains confidential between parties. Now, once the grounds of appeal are filed, the First Tier Tribunal, as you've seen for a standard or complex case, will direct HMRC to issue their statement of case, which is clearly their position on the matter and what they say the appellants have to do in order to meet the challenge in relation to the issue of the PLNs. Your Lordship then took my learned friend Mr. Pusey to Rule 27, which is the obligation to disclose documents upon which a party intends to rely. We have it here, but it's not in the bundles, and copies could be made, which were actually the First Tier Tribunal directions relating to disclosure. So a copy can be made. So HMRC issued its statement of case, and then the direction from the First Tier Tribunal addressed both Mr. Mitchell and Mr. Bell on the 15th of August 2018, and copies can be made.
Sorry, when in August?
15th of August
15th, thank you.
2018.
Yeah.
The first direction was 1, list of documents not later than the 14th of September 2018. Each party shall 1, send or deliver to each other party and the tribunal a list of documents in its possession or control which that party intends to rely upon or produce in connection with the appeal, documents list, and send or deliver to the other party copies of any documents on the documents list which have not already been provided to the other party, and confirm to the tribunal that they had done so. That mirrors what is in Rule 27. So that was...
all that did, by way of supplementation of Rule 27, was to set a date for it?
Yes,
yeah,
absolutely, my lord. But that was the direction at that point for each party to make disclosure of the documents which they wanted to rely on for the purposes of the proceedings. There is no form of standard disclosure within that wording. If a party seeks standard disclosure, it would be an application to the tribunal under Rule 5.
To be sure, and I assume you would accept that if such an application were made, the FTT would have power to order standard disclosure.
Yes, if the circumstances are obviously appropriate for that application. Equally, and it's important to draw this, in my view, to the court's attention, it's not just Rule 5, there is also a Rule 16, which I'm afraid is not in the bundle, but you can see what it looks like at tab 15, page 264 of the legal authorities bundle, which is embedded in the upper tribunal decision of McCabe, paragraph 20 free, and this is the point, so I'll just pause. So typically if a party,
I'm sorry, I must have the wrong page
I
because
must
I
as
can't
well.
see anything. about
page
rule-
264,
Yes.
Rule 15.
Sorry, rule 16.
Rule 16.
Rule
I mean,
16, sorry,
I
my
don't-
fault.
no, my fault. I don't see that.
Paragraph 23. Second, the FTT must exercise its discretion to order additional disclosure under Rule 16 so as to give effect to the overriding objective.
Right.
And 24. Further, the approach of the FTT to disclosure is not determined by the civil procedure rules. Rule 27 of the FTT rules, and this would just put it in context, in McCabe it was an application for specific disclosure by the taxpayer against HMRC seeking to obtain sight of documents which had been brought into existence between the Belgian and UK tax authorities. But I think it's important to bring it to this court's attention, which is its specific disclosure isn't just Rule 5, it is also, there's a specific power in Rule 16. And just going back to page 264, paragraph 24, the approach of the FTT to disclosure is not determined by the CPR. Rule 27 of the FTT rules states that a party must, amongst other things, produce a list of documents which that other party may inspect, which the party intends to rely upon or produce in the proceedings. Importantly, that rule applies to both standard and complex cases, 27.1. We've already observed that Rule 16 gives the FTT power to order the production of any document in a person's possession or control which relates to an issue in the proceedings. In e-buyer, one of the issues was whether it was an error of law by the FTT not to have displaced Rule 27 with what the Court of Appeal called the broader CPR-style disclosure. In determining that, the FTT had not so erred. Sir Geoffrey Voss C stated, "It's true this is an important case, but the 2009 rules were made for important as well as simple cases. The plain fact is the procedure is different in the FTT." And then at paragraph 25, you have the point about relevance and citing Smart Price Midlands, that, as you've seen, disclosure is not an end in itself, and that the filter is relevance. And just whilst we're in the legal authorities bundle, just to deal with this point now.
We don't have e-buyer, I think, in the bundle, do we?
No, we don't. Would it be
I think
convenient to obtain copies for the...
Well, we can
Cool.
obtain copies for ourselves. I don't know that we need. For my part, I shall certainly look it
But
up.
just so far as Rule 16 is concerned, as I understand it, what you're drawing to our attention is that that's an additional power in the FTT to order specific disclosure.
Yes.
And I think you're right to draw that to our attention because we need to take that into account. But why does it matter?
Well, it matters in circumstances where the starting position under Rule 27 is that the only obligation on any party to tax tribunal proceedings is clearly to disclose documents upon which they intend to rely or produce for the purposes of making good their case. And Rule 27 is going to be, in terms of the scope of the disclosure, that's going to be controlled by a party's statement of case. That's Burns Court of Appeal.
Well, that I have no problem with, but I'm struggling to understand the relevance of all of this.
Well-
because where we've got to is that you have accepted that by virtue of Section 18, Section 18, subsection 2 and C, HMRC has the power to produce the documents which it is intending to produce voluntarily. Therefore, no order for disclosure is required, and therefore, what relevance is powers and decisions with regard to disclosure obligation?
My lord, the point of bringing, going back to Rule 5 and Rule 16 is to emphasise the point that the appropriate stage for a party to seek specific disclosure, potentially adverse standard disclosure, is after there has been the general disclosure pursuant to Rule 27. So when this court has sight of, and we can hand it up now if it's possible to make a copy, if that would be of assistance, once a party has discharged their obligation in disclosing their list of documents, is then open to any party, whether it's HMRC or an appellant or co-appellant, to say, well, actually, we're not happy with the disclosure which has been made under Rule 27, or we feel that there are potentially documents within a specified class which are relevant, and we're going to apply for specific
On the
disclosure.
facts here, that's purely a timing problem, isn't it? Because with
Yes.
the writing's on the wall.
Yes,
So,
but sorry.
yeah, no.
But it's not only a timing question, it's also, it actually doesn't arise because I'm sure you're right that the right time to apply for specific disclosure is after general disclosure has been given under Rule 27. But disclosure, as I've commented already, is all about compulsion. It's about the FTT making an order.
Yes.
Whereas here, no order is required. HMRC have the power, you accept. They're proposing to do it voluntarily. And the question is, how can you stop them?
But the effect of the power is to override the obligation of confidence in relation to taxpayer information, which is held by HMRC. So going back to the point we started out with under Section 18, and I've taken the court to Ingenious, tab 9, paragraph 22 in the first instance, which was to emphasise, at page 145, paragraph 22, I say the analogue here is that HMRC has the possession of confidential information. I accept they have the power under Section 18 to make voluntary disclosure, but, if I may, subject to how that power is construed.
So that's your headline point. So in answer to my Lord's question about what is your position on Section 18, there is more to it.
Yes.
So are you tilting at a submission that the power which you accept exists under Section 18, tempered in subsection 2, tempered with the primary importance of confidentiality, is the power in some way, do you say, limited, where the statute says subsection 1 does not apply to a disclosure which is made for the purposes of civil proceedings, that in somehow one reads in a disclosure somehow made for the purpose of civil proceedings has to be tempered or limited by reference to, I don't know, relevant documents or something like that? Is that what you're tilting at?
My lady, yes, and
Right.
But that
I probably
that
haven't put it
wouldn't
very
tend-
well, but
no, that's
it's important to headline, secondly, so I
absolutely.
understand where you're going, what your position on the scope of the power or the manner in which the power can properly be exercised.
Sorry, it's my fault. I said at the outset that Section 18 provides a power on the face of it for voluntary disclosure by HMRC, but that, in my respectful submission, has to be tempered by a filter, and that filter is the common law on admissibility.
Yes, I understand that, but I still don't understand the answer to the question that I've put to you twice.
My lord,
And I
I'm sorry.
apologise. I'm sure it's my fault for not being clear enough, and appreciate you're trying to develop your submissions, and we're getting in the way, and I apologise for that as well. But
No, please.
I need to understand where you're going, which is why I'm asking the question. Because the question is this: how can you, Mr. Mitchell, stop HMRC from doing what it's proposing to do? If it was an application for judicial review, then that would be one way of stopping them.
Yes.
But that would require an application to be made, and it will require public law error. Absent an application for judicial review, and absent any suggestion of public law error, how do you stop them?
Well, the straightforward answer is making an application to the First Tier Tribunal.
But you didn't.
Well, Could I actually take
And what application would it be anyway?
your lordship to tab 2, the supplementary bundle, page 10?
What are we dealing with? My lord's asked you a question about procedure.
Yes.
Just don't want to forget, you were right in the middle of telling us what section 18.
Yes, sorry,
So
that's
can we
my
just
fault.
make sure we deal with both of those
Sorry, I'm
things?
skipping.
We're doing process now. We're going to procedure, are we?
No.
Substance.
Shall I just finish off on ingenious and the paragraphs there on section 18, if I may? I'm sorry.
That's fine. I'm there.
And page 144. So I've gone to 145, paragraph 22, and I emphasise the overarching principle of confidentiality. And if section 18 were to be construed widely, I accept on that view it would give the revenue a power to make voluntary disclosure. Absent this court not accepting my proposition that a filter is imposed on the... Well, I'll come back to how that filter would be applied. But if I may...
This, of course, was a judicial review application. That was the entire context.
Yes, it was a judicial review application, but it emphasises the obligation of confidentiality between taxpayer and HMRC.
To be sure, absolutely.
Absolutely.
And it's important from that point of view, I accept.
And section 18, too, in our respectful submission, has to be construed narrowly, because if it's not construed narrowly by reference to a filter, then HMRC has the unfettered power to make disclosure of any information concerning a taxpayer. And we say the necessary and appropriate filter to that power is that any information which is deployed by HMRC has to be relevant, i.e. admissible for the purposes of civil proceedings. And that is a point which, and I'll take your lordship and ladyships to the relevant paragraphs in the upper tribunal decision, they clearly adopted that approach. They applied a filter of admissibility.
So your submission, therefore, as I understand it, is that HMRC has no power to produce documents save those which are admissible in evidence.
Which are relevant, yes.
You said and admissible.
Yes, which are relevant.
But how can it be those which are admissible, given firstly that the FTT is not bound by strict rules of evidence, and secondly, it has an express power to exclude things that are admissible but unfair?
My lord, in answer directly to your point just now about the ability of the FTT to admit evidence which isn't strictly admissible in a civil trial, this has helpfully been dealt with by this court in Infinity Distribution, which is tab 10, paragraph 10, page 153.
Just before we go to Infinity, can I just articulate back to you? I want to make, this is the critical submission, so I just want to make sure that I've really understood it. And I think it comes to this, and please correct me if I'm wrong, that you say the FTT and in turn the UT were right to take relevance as the keystone of what HMRC could or had power to disclose. Relevance was to be assessed in terms of admissibility when it came to the hearing. Those things all allied. And to determine what's admissible, you look at HMRC's statement of case and ask yourself, what are the issues raised there? Is that roughly the sequence?
It is
thinking?
Absolutely the sequence, my lady. But I make no complaint about the fact that the FTT looked at both appellants' grounds of appeal.
Yeah.
And also Judge Mosedale made the point that she also listened to the parties' submissions.
So it went a little bit broader than...
That's right. Okay. And it was only during those submissions that Mr. Bell's counsel, this is there's no criticism, made the submission that at that point they were going to run a cutthroat defence.
If you were looking at the common law, you would never, maybe never is a dangerous word, but you would never override a party's confidentiality in order to produce an irrelevant document.
Yes, correct. Yes.
And I think what I gathered from Mr. Pusey for HMRC is he doesn't really accept, or he challenges, or he says that's where the error of law is in the FTT, that they said that details as between Mitchell and Bell were irrelevant, even taking account of what had been said, or it was premature, or whatever it was, but they didn't come within the relevance because it wouldn't be admissible at the time. And I think he says, no, that can't be right, because Bell was asking for them, he wanted to see them, and they were both running a cutthroat, one against the other.
Well, this goes back to the argument, the submissions that we've made in both the First Tier Tribunal and the Upper Tribunal, which is the appropriate filter, is admissibility. Now, when we saw HMRC's list of documents, Mr. Mitchell's legal team saw HMRC's list of documents, and as you can see from the procedural history, which is referred to in the opening paragraphs of both the FTT and UT decision, we identified on HMRC's list of documents, in our view, they were documents which should not be relied on for the purposes of the civil proceedings because they were irrelevant.
Not admissible.
And not admissible.
Therefore irrelevant, or irrelevant, therefore not
yes.
admissible. Whichever way round it goes.
Yes,
probably
absolutely. And that's why we developed our submission in the Upper Tribunal in relation to the Court of Appeal's decision in Burns, which we've referred to in our skeleton argument, and in particular I think it's paragraph 111 of the Court of Appeal decision in Burns, which very much emphasises in our respectful submission, quite rightly, the great importance which is to be attached to a statement of case, because it...
All right, but it's the fault of the court for asking you too many questions, but you were about to refer us to infinity distribution, and you've got on to Burns without taking us to the bit of infinity that you're relying on. So, take us in turn to the two cases, please.
Thank you. If we could go to infinity, tab 10, page 153, paragraph 10, judgment of Lord Justice Briggs, as he then was. This actually, as you will have seen from the head note, is effectively a propensity case and an application to strike out irrelevant material relating to two different types of witness statement. But the principle is at paragraphs 10 and 11. So 10, this is my Lord's point, which is under Rule 15, sub 2. The tribunal may A, admit evidence whether or not the evidence would be admissible in a civil trial in the UK, or exclude under B, evidence that would otherwise be admissible where it would be unfair to admit the evidence. Importantly, paragraph 11, notwithstanding that greater liberty of case management discretion, no one doubts that the FTT, like a civil court, will usually treat the question whether proffered evidence is relevant as a cardinal factor in deciding whether it should be admitted or excluded. The admission of evidence which is irrelevant is as detrimental to the economic and proportionate conduct of tribunal proceedings as it is in relation to court proceedings. Nonetheless, where irrelevant material is mixed up with relevant material, it may frequently be disproportionate to spend time before a final hearing disentangling the two. The admission of the irrelevant alongside the relevant material causes no unfairness or inconvenience, calling for active case management. And of course, what happened in these proceedings is that we identified very quickly from HMRC's list of documents, which were, that list was disclosed in discharge of Rule 27.1, that there were documents on there, in our view, which were irrelevant, therefore inadmissible, and that's why we made our application.
So okay, but again, I'm very sorry. I want you to have a chance to develop your submissions. You were referring to Burns. Is it convenient to go to that next before we start asking questions?
Yes.
Right.
If that's only convenient.
Yes. No, as I say, we must allow you time to.
No, I'm in your hands. I'm very happy to answer questions.
So Burns is tab 12.
Yes. Sorry, my lord. I was just looking for by reference name. Yes, so Burns, Financial Conduct Authority, and if I may go to page 202. And yes, so paragraph 104, just so you can see the analogue to the FTT rules. The proceedings before the tribunal are governed by the tribunal procedure, upper tribunal rules. The rules govern proceedings in all chambers of the UT. Some rules apply to all proceedings, whilst others apply specifically to particular types of proceedings. 105, the overriding objective of the rules is to enable the upper tribunal to deal with cases fairly and justly. Rule 2.1, obviously that's the same under the FTT rules. 106 of the rules contains provision for financial services cases, which includes references and respective decisions of the FCA. 107, Schedule 3 makes provision for statements of case. It's for the FCA to deliver the first statement in support of the referred action. Its statement must state the reasons for the referred action, set out all matters and facts upon which the respondent relies to support the referred action. And just so you have the comparison, keeping a finger in Burns, but going to, if you would, Rule 23C, sorry, tab 23C, page 329, you've got Rule 25. So a respondent, HMRC, sorry.
Sorry, can you read the page again?
Page 329, my lord.
Right.
Respondent statement of case, respondent, so this would be HMRC, must send or deliver a statement of case to the FTT, the appellant, and any other respondent so it's received, and this is C, in a standard or complex case within 60 days after the tribunal sent the notice of appeal or application notice. And then subsection 2, a statement of case must, in an appeal, state the legislative provision under which the decision under appeal was made, and B, set out the respondent's position in relation to the case. And of course, as I said earlier in my submissions, HMRC would have been investigating a group of taxpayers potentially for a very long period of time, so will be well in possession of the facts relating to any particular taxpayer and in a position to formulate their case. And
there's a mismatch, isn't there, between 27 and 25, because although 27 applies to complex cases, the provision of documents or identification of documents under Rule 27 has to be within 42 days, whereas by which time the respondent's statement of case won't be in. Not necessarily.
yes. Well, no.
We've got 60 days for that.
The statement of case comes first. So the grounds of appeal are filed with the First Tier Tribunal.
It's very odd to look at relevance before the other side's case is in.
Well, no, if I may, the FTT Tribunal then notifies HMRC as respondent of its obligation to provide the statement of case. And I think we do have
yes.
FTT directions on that point in this matter. Okay. So HMRC then issues its statement of case. Once the statement of case, thank you. Yes, so in this particular matter, and again, we'll make a copy of it for the courts, on the 19th of May 2018, the FTT directed that the appeals of Mr. Mitchell and Mr. Bell were to be joined and heard by the same tribunal. 2, the respondents shall provide a combined...
They weren't joined, they were heard together, weren't they? They weren't joined.
Shall proceed together and be heard together by the same tribunal. My apologies. 2, the respondents shall provide a combined statement of case addressing both appeals to the tribunal and the appellants within 60 days of the date of these directions. But I'll ask for a copy of it to be made. So that was on the 19th of May 2018, then you had subsequently this further directions, far more comprehensive, 15th of August 2018, which was then item 1, disclosure of the list of documents, and then you'll see item 2, appellants to provide their witness statements, item 3, the respondents to provide their witness statements, and then item 4, listing information.
As I understand it, and correct me if I've got this wrong, in neither of those sets of directions was any direction made for a statement of case from the appellants.
No, my lord. And that is not the standard set of directions.
Well, it may not be, but of course, how can one judge relevance without knowing what the appellant's cases are?
My lord, absolutely. And to that point, your lordship will see within the supplementary bundle, you've got HMRC's statement of case, which is at tab 9, starts at page 64. And what will happen, just to step back slightly, well, actually, I can take you directly to the point. Yes, so page 65, paragraph 6. So what will happen in a this is a supplementary bundle.
Yeah.
Tab 9, page 65. HMRC opened an investigation into the appellants, then issued a adverse decision letter saying we're going to issue PLNs. It's paragraphs 3 through to 6 for both Mr. Mitchell and, in fairness, pointing this out also for Mr. Bell, that it's also then possible, once an initial adverse decision has been issued, for an appellant to ask for a review of that decision, which is undertaken by an independent officer of HMRC, who may either uphold or not the original decision. Now, Mr. Mitchell submitted through his representative's BDO a particularised appeal asking for the independent review. And this is actually referred to at paragraph 3. Mr. Mitchell requested a review of the Mitchell Payroll PLN and the Mitchell Project PLN on the 5th of January 2018. The review combined both the Mitchell PLNs, which HMRC upheld by a letter dated the 12th of February 2018, and that's the decision which was appealed against by the notice of appeal. The reason I'm setting out this background is your lordship's point that relevance has to be determined by a party's pleadings, but an HMRC investigation is very different from normal, in my respectful submission, civil proceedings, because an investigation would have been opened a long time ago. There would have been an adverse decision, as there was here. There's the opportunity to then put forward further matters to be drawn to the attention of the reviewing officer, and then, assuming that's not upheld, the statement of case
All right, well, I
is
think
issued.
we need to get into the question of relevance at a later stage. Let's finish off on Burns, shall we? Because you got diverted from that. So why don't you complete taking us to the points of Burns that you want to rely upon?
So in relation to Burns, page 202, paragraph 110, it's clear from these provisions that the statements of case perform the vital function of informing each party in the tribunal of the other party's case, thereby enabling them to direct their evidence submissions to the issues identified by the statements. So the clear analogue here is that HMRC is required to provide a statement of case, and that provides the four corners of the civil tax litigation going forward, because that identifies to all parties what is the nature of the evidence and the submissions that they're going to make in due course. Going back to Burns 110, in particular, the respondent's statement informs the applicant of the case that he has to meet. Again, exactly the same for the taxpayer. The power of the tribunal to permit the amendment of statements shows that a party is not irrevocably bound by its original statement, but equally demonstrates the importance attached to them as the documents that define each party's case. 111, the importance of statements of case has been recognised in a number of financial services cases. And if I could invite this court to read either now or in due course 111 and 112.
Well, presumably the key point is the one made in 112, which says that statements of case are not essentially different to that and take court proceedings. They define the issues, assist in achieving a fair and efficient disposal of the case. I mean, that is do we get anything more out of it than that?
And also 113, which refers to the decision of Lord Justice Lawton in Rolled Steel Products. And I don't propose reading the whole extract, but obviously saying, I wish, however, to add a comment about the pleadings point which had to be considered in this appeal. From the way they were raised by counsel and dealt with by the trial judge, I was left with
Well, it's just simply saying they remain important, yeah?
And they, precisely, my lord, they remain very important because it informs the future direction of travel. And that's particularly in circumstances, I respectfully submit, where Rule 27 isn't akin to CPR, standard disclosure.
Certainly isn't. But anyway, so what you rely upon Burns for is the proposition that statements of case are important.
Very important in our respect.
Very important, all right? Yes.
Particularly in tax cases, because, as I say, Rule 27 is not standard disclosure.
Right. Now, you have referred twice to an application made by your client, and I think we would find it helpful if we could have a look at that.
My lord, yes.
So that's tab 2 of the supplemental bundle.
It is. So if I go to the supplementary bundle, put that there, and Mr. Mitchell's application.
So this is the one you're talking about?
Yes, this was the application. So we identified on the list of documents that there are items there, the 2 volumes of disputed documents. Which
So can you help me on this? Because I'm struggling to understand this, because you referred to this in the context of my question as to what Mr. Mitchell's ability was to stop HMRC doing that which HMRC has power to do and is voluntarily proposing to do. And what I find difficult to understand about this is that if we look at the application in paragraph 1, what it says is Mr. Mitchell applies for a direction by the tribunal under various rules that A, the respondent's application for disclosure is refused, but the respondent wasn't applying for disclosure. HMRC is not seeking disclosure. It is proposing voluntarily to produce documents. So I come back to my question. How can you stop them?
that's under Rule 15, 2C, my lord, and that's the passage in infinity distribution, which I took your lordship to, where Lord Justice Briggs, as he then was, set out Rule 15, and then in paragraph 11 said the necessary filter.
I'm not understanding this. Rule 15.2c is about omission in evidence if unfair. Yes?
Yes.
What's that got to do with voluntary production of documents? And particularly, what's it got to do with relevance? Because the criterion under 15.2c is unfairness, it's not relevance.
My answer is that, relying on the passage of paragraph 11 of Lord Justice Briggs, which is, in looking at Rule 15.2b3, it has the power to exclude
B3,
evidence.
I'm sorry, I'm confused. I thought it was C you were relying on.
No, my lord. So in our application we refer to...
Sorry, we need to look at the rule again, I apologise.
B3.
Oh, sorry, yes, that's my fault. I was misspeaking. Yes, okay, understood, yes.
So paragraph 1 of our application to the FTT, page 10 supplementary bundle, that does refer to Rules 2, overriding objective, Rule 5, case management,
Right.
and Rule 15.2b3, which is the power to exclude evidence.
Right.
Now,
But what's
as Lord
that got to do with production of documents?
Now, as Lord Justice Briggs said at paragraph 11, in applying that rule, you apply first the filter of admissibility. And likewise, if a party makes an application for specific disclosure of evidence,
Which there isn't, yes, go on.
well, for completeness, in very short order, the specific disclosure application only passes muster if it passes a threshold test of relevance. So any application for specific disclosure has to be for relevant material. And as the upper tribunal, I took this court to McCabe, and the upper tribunal there, as you I think saw, the fifth point refers to the Court of Appeal decision in Smart Price, and disclosure application is framed by
I'm sorry, I'm getting lost with all these references to disclosure when we're not concerned with disclosure. So can I see if I've understood your submission? Your submission is that Rule 15 2b little 3 empowers the First Tier Tribunal to prevent HMRC from voluntarily producing documents under Rule 27(2). Is that correct?
Yes, my lord.
And how do you get that out of the rules?
Because that's the way in which the First Tier Tribunal and Upper Tribunal have approached this matter. Because the application...
But whether they did or they didn't, my question is, why is it right?
Because it's, well... My lord, could I just... Yes, so it's Rule 15. The only ability a taxpayer has in terms of seeking to invite the FTT to control evidence is through Rule 15 specifically, which is the only specific power dealing with evidence and submissions.
That's about admission in evidence, isn't it?
Yes, subject.
So what's that got to do with production of documents by HMRC using its power under Section 18 and Rule 27(2)?
Subject to this point, which is under Rule 5,
Right.
page 323, the tribunal has the power to regulate its own procedure. And procedure, in my respectful submission, also includes, well, clearly includes case management decisions, but case management decisions over what is capable of being relied on for the purposes of the proceedings, because...
So let me see if I've understood that submission. So do I understand you there to be making the submission that even if there is no power in Rule 15(2)(b)(3), somewhere within Rule 5, and you'll tell us where, there is power in the FTT to stop HMRC exercising its power under Section 18 to voluntarily produce documents?
Well, under Rule 5.2, the tribunal may give a direction in relation to the conduct or disposal of proceedings at any time. So the conduct of proceedings must include what a party is seeking to rely on for the purposes of the proceedings.
So your submission is that either Rule 15(2)(b)(3 or alternatively Rule 5.2 empowers the FTT to make an order prohibiting HMRC from exercising its power under Section 18 and Rule 27(2).
Well, and my lord, if we go back to Rule 15, because of course I've not covered the earlier subsections, page 325. Rule 15.1, and although Rule 15 is the specific power dealing with evidence and provisions, it would be remiss of me not to go through the opening sub-rules. 15.1, without restriction on the general powers in Rules 5 and 2, case management powers, the tribunal may give directions as to, so this rule recognises that Rule 5 is wide in its scope for case management powers, but yet, quite rightly, we have specific rules dealing with evidence and submissions. So A, it can give directions as to the issues on which it requires evidence or submissions. B, the nature of the evidence or submissions it requires, so the tribunal has the power to direct what type of evidence it hears. C, deals specifically with the ability to provide expert evidence, witnesses. E, the manner in which any evidence or submissions are to be provided, which may include directions for them to be given orally at the hearing or by written
Let me
submission.
be clear. Is it your submission that Rule 15.1 empowers the FTT to make an order prohibiting HMRC from exercising its powers under Section 18 of Rule 27.2?
It does not expressly say that, my lord.
So which are the ones you're relying on? And so far we've got 15.2b3 and 5.2. Any more?
And no, my lord.
So you say Rule 15.2b3, alternatively Rule 5.2, empowers the FTT to make an order prohibiting HMRC from exercising its powers under Section 18 of the Act and Rule 27.2.
My lord, prohibiting through the lens of the common law relating to admissibility.
Because you say everything that HMRC, I'm just trying to summarise, if I may. I think where your
Sorry,
argument
it's
is,
my
if I
fault.
may, just pick it up, because you ally the concept of disclosure with what's admissible as evidence
Yes.
at the hearing, and that's either right or wrong. And
Yes,
we'll just
absolutely.
look at it. But the FTT certainly thought that was a sound submission, and once you do that, you say that what the only things that HMRC can properly disclose under Section 18 and or Rule 27 are things that would be admissible in evidence because they would be relevant to the pleaded case, effectively.
My
That-
lady,
that's,
yes,
is
it.
that kind of where we are?
Yes, I wish I could have expressed it.
No, please don't. I just wanted to make sure I'd caught up with you, and I think that's where
It is.
the case is.
Could I, on that point, and I mentioned this at the outset, give some references in the upper tribunal decision?
Well, before we start looking at decisions, can you help me on this? Because in answer to my lady, you have agreed that the criterion is relevance. But on the face of Rule 15.2b3, the criterion is not relevance, but unfairness.
But to be read in our respectful submission with that passage, which I took your lordship to, paragraph 11, Lord Justice Briggs, infinity distribution, which is, whilst Lord Justice Briggs, as he then was, recognised that on the face of it, Rule 15 gives wide power to the FTT to admit non-admissible evidence. At paragraph 11, in our respectful submission, the right approach is to apply the filter of...
So let me pose my question again in a different way. Do you say that Rule 15.2b3 empowers the FTT to exclude evidence which is not irrelevant?
Yes, it has the power to exclude.
No, I think you say no because not irrelevant is the same as relevant.
Yeah.
And I think where you've pitched your tent is on the relevance-irrelevance margin.
Okay,
So
sorry,
you would say
I
it was
misspoke.
irrelevant.
What I meant to say is it's not unfair. So can it exclude evidence, the admission of which is not unfair?
Yes, because of the filter of relevance, my lord.
So even though on the face of the rule it poses a test of unfairness, you say we substitute relevance for unfairness.
Well, it's a two-stage test. First is relevance. If it passes the test of relevance, the next question is it unfair for it to be relied on? And that's in a matter the upper tribunal rejected Mr. Mitchell's appeal because our appeal in the upper tribunal was in relation to either A, not relevant, or if it is relevant, then it would be unfair. Upper tribunal decided we're not going to deal with the unfairness point, then they solely deal with relevant.
How, if it was relevant, could it be unfair on the facts of this case?
Well, sorry, could I actually repeat
Yes,
the question?
if relevant, how could, on the facts of this case, how could disclosure of a particular document or note be unfair?
It would depend, obviously, on the nature of the documents.
I'm just struggling to think of an example.
Bundles. So let's, if I could take a hypothetical to avoid getting into the disputed documents. Let's say that someone had entered into a agreement with HMRC to pay an amount of tax on the basis of a Code of Practice 9. So it made an admission of tax fraud in relation to part of their life, which on one view that might be said to be potentially relevant, but how do you identify the relevance? That goes back to the revenues statement of case. What are the issues in dispute? The only issues in dispute in this appeal, in relation to the PLN, is, well, there's three really. One, whether or not the corporate liability notices were validly issued to the companies, which the FTT will have jurisdiction to consider. Assuming they are valid, the second question is whether or not Mr. Mitchell and or Mr. Bell are shadow directors, i.e. was a director of record used to acting on either of their directions such that either of them were shadow directors. That's a question of fact. And issue 3, in no particular order, to the extent that there was any tax insufficiency brought about deliberately, is that attributable to either of the appellants? Now, the first...
Can I ask you this question? HMRC is proposing to exercise its power under Section 18 to disclose these documents, to produce these documents, because HMRC believe that the documents may assist Mr. Bell. Is it your submission that that belief is unreasonable?
Well, when we first... I will answer your Lordship's question, but I think it's necessary to give something of the flavour. When we first saw the list of documents and arrived at the doorstep of the First Tier Tribunal, and this is reflected in Judge Maysdale's decision, HMRC accepted 8 of the documents were irrelevant. So those were automatically taken off the list. And clearly, Mr. Bell has adopted the position that if HMRC aren't interested in relying on the documents for the purposes of their prosecution of the PLNs, then he has no interest in seeing them. So he has aligned his position from day one in the FTT with the position of HMRC. So we've had 8 which were accepted to be irrelevant. Counsel then representing HMRC, Richard Chapman KC, as you've seen from the FTT decision, provided a 4-level list of relevance, which I fed into during the course of the proceedings. And then you obviously have Judge Maysdale's decision limiting that, for example, in relation to 2B, it has to be relevant by reference to what HMRC pleads in its statement of case, and then level 4 documents are irrelevant in the judge's view below, on the basis that general credibility isn't an issue. So I haven't answered your Lordship's question directly, which is, do I think HMRC's being unreasonable?
Is it your submission that their belief the documents in dispute on this appeal may assist Mr. Bell unreasonable? Or irrational? Let's use the word irrational. Is it irrational?
I don't... We've clearly not made an application for judicial review. We haven't sought to invoke any public law remedy.
So you accept it's rational.
Well, at this point, we've not sought to invoke any public law remedy because we've had a remedy in the FTT, in the upper tribunal, and the fact that we're here reflects that there is a remedy available to Mr. Mitchell, and we wouldn't be able to launch any form of public law challenge, certainly at this stage. Mr.
Well, that
Mitchell
depends on our decision, because if we decide that there's no power under Rule 15.2b3 or Rule 5.2, then your only remedy is a public law one.
My lord, yes.
So-
Subject to exhausting any
But
legitimate.
I come back to the question, is it your submission that HMRC's position is irrational?
I can't say that it's irrational because we have not appealed against the decision of the upper tribunal. We are content with the scope of the levels of relevance.
Is that HMRC are not content?
Well,
So I'm afraid I require a yes or a no answer. Is it your submission that HMRC's position that the documents in dispute on this appeal may assist Mr. Bell irrational? It's yes or no.
I can't say that their position is irrational, my lord. No.
Right. So if it's not irrational, upon what basis do you say that the court can go behind it?
Well, I go back to and rely on my earlier submissions, my lord. If I could add, and I wouldn't be doing my job if I didn't make this submission, HMRC were quite content with Judge Mosedale's decision. They never appealed the FTT decision.
But Mr. Bell did.
Yes, Mr. Bell, as he was rightly entitled to do, did appeal the FTT decision. There was no revenue appeal to the upper tribunal. The revenue assisted by making, quite rightly, I accept, submissions on the disputed documents. But I come back to, and perhaps I can't assist this court any further, but when we saw the list of documents which were provided by HMRC, and this is reflected in Judge Mosedale's decision, and HMRC agree this point, there is material in the disputed documents which Mr. Mitchell would not want in the public domain. And we are seeking...
That's a different matter, because that could be dealt with by a confidentiality club. So concerns about what goes into the public domain have got nothing to do with this. The question is, can Mr. Mitchell stop the tribunal seeing the documents?
The tribunal have seen the documents, my lord.
No, at trial.
If they're irrelevant, the power exists to exclude.
If the admission of them is unfair, then there's plainly a power to exclude, and Mr. Aiken has accepted that that's a question for another day. So Mr. Mitchell, even if we allow the appeal, will be able to say to the FTT at a later stage that these documents should not be admitted in evidence because it will be unfair. But none of that's got anything to do with releasing the documents into the public domain, has it?
Well, once they've gone, assuming the disputed documents go into the hands of Mr. Bell and his representatives, they have them and can decide what they want to do with them and to decide how they deploy them. It's equally open.
Yeah, but hold on. Mr. Bell doesn't want to give the documents to a journalist. That's not what this dispute is about.
Absolutely not.
I'm sorry, are you seriously submitting that Mr. Mitchell's concern is that the documents will be shown to journalists?
No, Mr. Mitchell's concern is that irrelevant documents go in front of an FTT judge. And if I'm
No, damaging documents. That's why you're here. He's concerned that he's going to be damaged before the FTT. If they were truly irrelevant, he wouldn't be worried.
Well, I'm not sure I'm quite with my lord on the approach. My understanding is that Mr. Mitchell's complaint is that there's a breach of confidence, and that's why he's concerned about
Yes.
this. And as I've understood your submissions, really, I think you have put in a respondent's notice. What you really say is the upper tribunal got it right for the reasons that it gave.
My lady,
You're just
yes.
seeking to uphold a decision that's been given in your favour, which
Yes.
is not unusual in this court.
Absolutely, and of course you're entitled to do that. But I come back to my question. If the concern was about documents going into the public domain, why would that not be adequately addressed by a confidentiality club?
Because for the overarching principle, well, the starting point of the FTT will be justice not only has to be done, it has to be seen to be done, quite rightly. Banerjee against HMRC, High Court decision of Sir Lancelot Henderson, as he then was. In order for any document, once it is on someone's list and they say they are going to rely on it for the purposes of Rule 27, it is, absent any counter application which is successful in the FTT, capable of being relied on and put to someone in cross-examination, whether it's relevant or irrelevant. Obviously, I accept it is fully open to me to make an application later under Rule 15 to make an application for evidence to be excluded on the basis that it's unfair. Again, the approach will be as it was in the First Tier Tribunal, that it's irrelevant, inadmissible, and then in the alternative seeking to apply for it to be excluded because it's unfair. If I'm not successful in any of those applications, and so Judge Mosedale's filters are not applied, and let's say level 4 material is used, any First Tier Tribunal judge, entirely rightly a matter for them, acting independently, to refer to whatever they want to in the course of that judgment. Yes, I accept I can make an application for matters to be redacted, but once any decision is published, it's in the public domain. And that's
sorry, I
then
don't
damaging to
understand
Mr.
this.
Mitchell's character.
So let me assist. As you may know, my speciality is intellectual property law, and in particular patents. In the world of patents, we deal with confidential information, and not just confidential information, high-grade confidential information, true trade secrets, all the time.
My lord, yes.
And it is absolutely routine for that to be dealt with by the documents being disclosed, subject to a confidentiality club, and you have restrictions upon who can see the documents and upon what terms. And then when it goes to trial, if necessary, generally speaking, we deal with most of that by simply not reading out the document in open court and making an order under 3122 of the CPR. If necessary, you will have a section of the hearing in private. And then when it comes to the judgment, the confidential material will either be referred to in a way that doesn't betray the confidential information, or if that can't be avoided, you put it in a confidential annex and it goes to the parties only and not into public. So it is absolutely well established that courts can and do deal with highly confidential information without it going into the public domain. There are procedures to avoid that problem. So I come back to my question. If Mr. Mitchell's concern is information going into the public domain, why can that not be dealt with by applications of those kind of procedures?
My lord, that sounds like a very sensible way forward, and obviously that's something which is applied in the context of intellectual property proceedings. I personally, and perhaps it's my own limitation, haven't come across that in the context of tax proceedings. And that would obviously require HMRC and Mr. Bell to agree.
No, it doesn't. Court can impose it.
But subject...
And the FTT must have the same powers, given what's in Rule 5.
But subject, obviously, to any counter submissions made by HMRC or Mr. Bell.
Well, of course, an order wouldn't be made without hearing the parties, to be sure, yes. But assume that an order is made for a confidentiality club. Why does that not address the concern about the public domain?
it would address subject to, and I don't have the rules in front of me. There is a rule, perhaps Mr. Pusey, I think, might have it.
There's Rule 14 of the Tribunal rules that enables the Tribunal to prohibit disclosure or publication of material that shouldn't be in the public domain.
Right. So there's an express power. Yeah.
As I understand your position, all of that discussion is premised on the documents being relevant.
Yes.
So your position is as a matter of principle, going back to your position on confidentiality, that whether or not there's protection down the line, or all of that is only engaged once you're talking about documents that are relevant. And I don't know, but perhaps later on, I think I certainly would benefit from understanding your position in response to the challenge on the views taken below that the documents in 2B and 4 are irrelevant. Because as I, having reminded myself of the grounds of appeal and the rest of it, there is a head-on challenge to the approach taken to relevance, isn't there?
Yes, unless I can...
No, I'm not saying you finished with this debate by any means, but I just wanted to understand where you're coming from.
Yes.
Am I right in understanding where you're coming from?
Yes, our head-on challenge in relation to
Yes.
Mr. Bell's grounds of
If
appeal.
relevant, you might go on to seek additional protection by way of confidentiality clubs and the like. But your position is, well, we're not there
Yes.
because these documents are not relevant as found by the judge. And at some stage, as I say, I would be assisted by understanding that
Yes.
position. I mean, I know you've taken us to the authorities on, well, it's all about the statements of case.
Yes. And I think to answer that, I will need to go into HMRC's statement of case.
Right, okay. But now may not be the time. I just
No,
wanted to
I'm
make sure I'd
just looking at
understand
the clock.
your response, yes.
So, as you will appreciate, we have questions, but as I've said before, we must allow you to develop your submission. So where would you like to go to next?
I finish my submissions unless I can be of any further assistance on section 18. My submissions on various powers in the FTT rules. I think if it would be of assistance to this court after the short adjournment, I would propose going to and dealing with the grounds of appeal on level 2B and level 4. In a nutshell, our case is as set out in our skeleton argument, and what it comes down to is both articulated in the First Tier Tribunal and the Upper Tribunal is admissibility. It's irrelevant.
Well,
and
I understand, of course, you're entitled to rely upon the decisions in your favour, and you do. That's axiomatic. But can you assist me on this? Given that this is something that HMRC is doing voluntarily, why is, and given that HMRC knows what's in the documents, Mr. Bell doesn't, why is not HMRC entitled to take its own view as to relevance, particularly when you accept that its view is not irrational?
And this is for the reasons, and I'm afraid I do rely on the Upper Tribunal, First Tier Tribunal decisions. It all comes back to the statement.
But those decisions are premised upon it not being a decision for HMRC. And that's what I'm questioning.
My Lord, if you're against me on section 18, then there's probably nothing I can say
That's it.
on level 2B and level 4, which is of assistance to the...
Well, except that you do have some explicit findings in your favour by Judge Mosdale
Yes.
on categories 2B and 4,
Yes.
that they are irrelevant to
Precisely.
the issues.
Precisely.
So I think you are entitled to just take us through that, because
Thank
you maintain that. That's a finding in your
Oh,
favour in
absolutely.
the FTT,
Those,
upheld by the UT.
and obviously this court is well aware to the point that those were decisions of specialist
Yeah.
tribunals. Forgive me obviously saying that, but both the First Tier Tribunal judge and the Upper Tribunal judges had the benefit of, I call it a benefit, of going through the disputed documents with submissions both from myself and HMRC HMRC submissions by Mr. Richard Chapman KC and submissions by Ms. Goldring, and you'll see in the disputed documents bundle it's in 3 divisions. Tab 1, Volume 1, is the unredacted FTT decision. Tab 2 is the transcript of the closed proceedings in the upper tribunal, where Ms. Goldring and myself made submissions to Judge Jonathan Richards and Judge Cannan on the disputed documents. And then in tab 3, but it doesn't actually say tab 3, you've got each of the tabs of the disputed documents, and the tabs, they're numbered in the way they are because
I
it
don't think we
reflects...
have the unredacted decision note.
You
Where is
do,
it?
and it
Is
is
that-
in
Oh, sorry, what tab
Volume 1
Got it.
and tab 1.
So to summarise, your submission is that the FTT has the power, under the rules that you rely upon, to prevent HMRC from exercising its powers under Section 18 in circumstances where, even though HMRC rationally believes the documents to be sufficiently relevant to be producible voluntarily, the FTT has power to stop HMRC from doing that in circumstances where the FTT considers that although that is HMRC's rational belief, it is objectively wrong.
Yes, my lord. And
That's your submission.
And that was also the decision of the upper tribunal.
All right. That's clear. Thank you very much.
Is this a
So
convenient...
we'll resume at 2 o'clock.
My lord, thank you.
Your turn.